to the news that is breaking out of Georgia. Two important things are happening. First, Fani Willis has defied the Georgia State Senate subpoena ahead of their hearing today. It's an oversight committee, the Senate Special Committee on Investigations, chaired by a Republican state senator, Bill Cowsert, who subpoenaed Willis to compel her testimony related to the committee's investigations into the misuse of the taxpayer funds, the $865,000 she sent to her friend, that special counsel, who then had to leave the case after admitting to the fact that he had no experience at all to do the work of a special counsel in this kind of RICO investigation. So again, it wasn't about the entire case. It wasn't whether or not she should be bringing charges against President Trump or not. It was about the misuse of taxpayer funds, and yet she refused to show up.
The Fani Willis determination to just go ahead and not show up after being subpoenaed by the legislative body of the state of Georgia, it shows that she herself holds a two-tiered system of justice for individuals in the state of Georgia. She, the entire time, tried to preach that Donald Trump wasn't above the law. No one's above the law when it comes to the justice system of Georgia. But however, when the Senate of Georgia issues a subpoena after you decline to voluntarily show up, and then you're subpoenaed by the Senate, things that an investigative body, an oversight body in the Georgia State House can do, you defy it by not showing up. It shows that you don't really believe that no one is above the law. Fani Willis herself thinks she's above the law and can just defy a subpoena by the Georgia Senate. Now, the Georgia Senate is saying that they are going to go to court and try to compel her through a court order to obey the subpoena, where they would receive documents and testimony from her. But it seems that at a time where she probably doesn't want to be making more waves as we await this oral argument in December, she's going to continue to do her own thing. I almost half expected her to bust into the Senate chamber and say, "Here I am," just like she did in that hearing.
At that same time, while the appeal's moving, the trial court judge, has dropped yet more charges against Donald Trump that he will not be taken to court over.
This one we still need to keep our eye on. We see that 2 more charges were dropped. They were attempt to commit false filing of documents and conspiracy to commit false filing of documents, because the judge said the state didn't have the authority to bring these charges because the allegation had to do with a federal court filing, not to do with a state issue.
The trial court judge who said, you know what, this is the state of Georgia. You are a DA in Fulton County. You can't bring federal charges against President Trump.
And Judge McAfee had previously dismissed some other charges. So now President Trump was originally charged with 13 counts. Now he's down to facing 8 counts in Georgia. So they're chipping away with these motions filed by the attorneys in this case at even the broad case that Fani Willis had brought originally, now down to 8 counts against President Trump. However, the case still lingers there, and it's in a sort of legal purgatory as we wait on the appeal at the Georgia Appeals Court. As you mentioned, Jordan, we filed our brief in that appeal on the disqualification of Fani Willis, which will be heard in an oral argument on December 5th. We probably won't get an answer to that until early 2025, after the inauguration of the next president of the United States.
What we say and preach at the ACLJ, we live and work. That when we say we want to defend your right to vote, we want to defend election integrity, it's not a partisan issue. It's an issue that all Americans should be concerned about, especially when you see one major political party bullying these other smaller political parties only to play politics. I mean, for no legitimate other reason. And Dad, Chief Counsel of the ACLJ, Jay Secchio, is joining us. And Dad, what we're seeing again is the Democrats, they're back trying to tell Americans who they can vote for, this time in Nevada.
Yeah, this is a trend we've seen, and that is these attempts to deny the American people choices that are really put in place by duly authorized campaigns. The fact is, as you said, Jordan, we're representing the Green Party. And by the way, this is not the first time that we've represented groups that ideologically you may not line up with, which we've represented the Hare Krishnas, we represented the National Democratic Policy Committee. at the Supreme Court. So, I mean, you do cases where it impacts, as you said, you put your money where your mouth is and you live the principles that you believe in. What happened to the Green Party in Nevada is so outrageous that the Democrats did this, and that was they were about to submit their form that they used to get candidate signatures so you can get independent third parties on the ballot. They got enough of those. The state certified it. The state actually sent them, the Secretary of State's office sent them a form. And that form that they used was the form that the state wanted them to use to gather the signatures that had certain designations on it. They used that form. They originally were going to use a different form, but they used that form. And then when they turned it in, the National Democratic Policy Committee files a lawsuit, and the court says, oh, yeah, the form that the state told you to use, that was the wrong form, therefore you're off the ballot. You talk about outrageous. That's about as outrageous in an election as it gets.
And courts have said over and over again, you can't be punished by following the state who had the correct authority there by following their rules.
No, here's what it means. It means the state of Nevada told you to use a particular document. You use the document pursuant to the state of Nevada's demand. And then the state of Nevada, the same officials tell you, oh, you used the wrong document. You cannot have your votes counted. I mean, that's what they've done here. Can the states do this? And the answer better be, when this is done at the Supreme Court, the answer better be no.
Tell people what we're asking the court to do, Dad, because this is something where time is very important.
Because the ballots have to be printed and early balloting starts very soon, we've asked the court to take the petition that we filed. The application is actually an application for a stay and a summary reversal, basically, turn it into a cert petition, which means then the court takes that application, the same court, and says, no, we're going to consider this a cert petition, grant the cert petition, and get the case over with, maybe with no additional briefing. There may need to be additional briefing. That's going to be totally up to the court. But our team moved in record speed and filed a great document.
This is why it's when Harris can get up there, they start redefining terms like, what does freedom mean? What does choice mean? Well, you know, in some states that means, oh, no, you've got to keep RFK on the ballot. You can't take him off. He has to be on. He qualified, even though he's asked to be taken off. And there is a process to do that because he's no longer a candidate for president of the United States. And yet, when it's Nevada, they say, oh, no. Take the Green Party off. They followed all the rules from the Secretary of State. Unfortunately, the Secretary of State, who's a Democrat and a Democrat Party member, told them to use forms that were wrong. And so because of that, the Democrat Party of Nevada said, you got to take them off. So in their situation, though they did everything right under what the state told them to do, you can't let them be on the ballot. And that's because they think they'll take votes away from Harris. But they would make the opposite argument if it was RFK, because they think he will take votes away from Donald Trump. It doesn't work that way in the United States. It shouldn't work that way in the United States. It's like that 14th Amendment issue. If you follow the rules, you should be treated equally, whether you are, as they call them, a minority political party or one of the two major political parties.